Perfect. Well, so my name is Caroline, and I'll be taking you through this presentation on trans and non-binary rights under European Court of Human Rights jurisprudence. So we'll be looking at a few different issues today. So first, I'll just be going through a short case law review, then we'll be looking at some examples of key notions in the European Court of Human Rights jurisprudence. There's a lot of them to cover, so sadly I won't have time to cover everything in 20 minutes, but I'll try as much as I can. And then we'll get to some contentious issues, and a lot of them have already been mentioned in the very interesting presentations before me. So we'll be looking at those and what the court has to say about those as well. And finally, we're going to be looking at some future pending cases and where the court might be going in the future. So yeah, I'm trying to establish where the court stands now and where we can imagine it going in the near future. So I've chosen to focus in on some more specific aspects of the case law of the court. So I'm not going to take you through a whole retelling of all the cases, even though that would be very interesting, but I don't think we have time for all of that necessarily. So just to give you a very quick idea of the case law of the court and the evolution of the case law of the court, here's a very, very reduced timeline of those cases. So as you can see at the beginning, when the court was first confronted with trans rights issues, it decided not to find violations in the cases of trans persons who were being refused legal gender recognition in their own countries. So that's the case you can see here, Ruiz versus UK, for example, in 1986, which was the first case that the court had to decide on the issue. And then through a few cases, and it did recognize somewhat of a right in 1992 in the case of B versus France, but that was more so of a factual case. So it was only in 2002 that the court really decided on a general right to gender identity in the case of Christine Goodwin versus France. And then even after that, there were some ups and downs in the court's legislation. So Anna already mentioned the case of Hämäläinen versus Finland, for example, where trans persons were not allowed to remain in same-sex marriages after their transition, when their marriages became same-sex marriages as of their legal gender recognition. But then recently we've had the case of, well, recently 4 years ago now, but the case of AP Garçon and Nico versus France in 2017, which was a major case in that it recognized that sterilization requirements for legal gender recognition were a violation of the European Convention of Human Rights. So that was a great achievement in itself. There's also some downsides in that case that we'll definitely be going through as well. But yeah, so as you can see, there's been some very important judgments, but as you can see from the timeline as well, this has taken a very, very long time and a lot of work from trans activists and trans persons who've spent high amounts of energy on this and still haven't gone as far as I guess we would have hoped to be today. So now that we have quite a general idea of the general timeline that we're operating in, I'd like to focus in on some more specific concepts and notions that the court has applied through the years. So I'll only be taking you through 3 of them today, but I hope they give some kind of an overview of what the jurisprudence looks like. So the first of those is the margin of appreciation that is left to states in their enforcement of the rights contained in the convention. So at the very beginning of the court treating trans rights, it decided that there was a wide margin of appreciation left to states on the decision to legally recognize the gender identity of trans persons. And that was based on the lack of consensus among states on the issue. So that was, for example, the decision taken in Ruiz versus UK in 1986, once again. However, then in later cases, the court started to looking at another aspect of the margin of appreciation that helped determine the width of the margin. And that was the issue of whether it was a particularly important issue to the person's identity or existence. And that then narrowed the margin of appreciation that was left to states based on that, because it was decided that gender identity is a fundamental aspect of the right to respect for private life. That was, for example, said in the case of AP Garçon and Nico versus France. However, this idea of a wide and narrow margin of appreciation isn't always very clear. So for example, even though gender identity generally falls into the narrow margin of appreciation category, that's not the case for all issues. So for example, in the case of AP Garçon and Nico versus France, when the court had to decide on the requirement of a gender identity disorder in order to recognize legal gender for trans persons, the court decided that it would apply a wide margin of appreciation on that case, based on the fact that a vast majority of states were still applying such a requirement. And as such, there was no consensus not to have that requirement. So it's still a bit unclear as well how the consensus argument itself is applied. As you can see from that, it kind of goes both ways. And sometimes the court won't even take into account an existing consensus in order to determine these decisions. It really varies how the court applies it. So it can be quite unpredictable as well. But even when it does, it also does it in a variety of ways. So for example, it will be looking at internal sources or sometimes international sources as well, meaning that you don't necessarily need a consensus of Council of Europe states, for example. It can come from really a variety of sources. And for example, in the case of Christine Goodwin versus UK, there was no consensus among Council of Europe states in that case, but the court noted that there was clear and uncontested evidence of a continuing international trend towards recognizing the gender identity of trans persons. And that was then held to have higher importance than the lack of consensus among Council of Europe states. And that's then a principle that the court has used again throughout the years. So for example, in YY versus Turkey in 2015, the court used that principle again, despite the lack of a common European approach. So this idea has led academics as well to argue that even though there is no consensus on complete demedicalization of legal gender recognition within Council of Europe states, there is definitely a clear and continuous trend towards such an approach. So both within Council of Europe states, but also outside. So you have many countries such as Argentina, Belgium, Chile, Denmark, Iceland, Ireland, Luxembourg, Malta, and the list goes on of cases that have already demedicalized the whole process. So the court could definitely rely on that as a consensus if it were to follow its own jurisprudence on that matter. But as I mentioned, it can be quite unpredictable. So it's a bit unclear how the court would decide on the issue, but we'll get to that as well. So the last point I want to touch on here is the idea of an impossible dilemma that the court has been using in recent years. And that's the dilemma that arises when surgical requirements are imposed on trans persons in order to have their gender legally recognized. So the court has decided that where surgical interventions are a requirement for trans persons to have their gender legally recognized, it puts them in a position where they effectively are obliged to undergo these surgeries if they want to exist as themselves legally. And that is completely independent of whether or not they would have wanted the surgeries or not. So it's really what the court has called not genuine consent in the AP Hansen and Nico versus France. So it's kind of vitiated by that kind of reward of being legally recognized at the end. So it's not true consent, it's not genuine consent, as the court had said here. So the court has then called that an impossible dilemma of having to choose between your right to gender identity and your right to respect for physical integrity. And that was also said again in the case of X and Y versus Romania at the very beginning of this year. So that now means that those surgical requirements and sterilization requirements cannot be imposed anymore within Council of Europe states. So that was a major advancement of the court, and that was great. But there's also a lot of more contentious issues now that I'd like to get into. Sorry, excuse me. So arguably one of the biggest points of contention here in the court's jurisprudence is that the court has not recognized the right to self-determination. So as was just discussed before me by Damon, the court hasn't recognized one of those in the Council of Europe states. So they're not obliged to have such a right in their legislation yet. So although the court is slowly lowering the requirements, as I mentioned, with no surgical requirements, for example, it still hasn't interpreted Article 8 on right to private life to include a right to self-determine your identity completely. So for example, in the case of AP Hansen Nico versus France, that I mentioned earlier as well, the court didn't find a violation in the requirement of medical diagnosis of a gender identity disorder. And the court could have taken that as an opportunity really to set out a clear right to self-determination. It would have been a perfect example of just how to do it, but sadly the court didn't take that route, even though there was that there are those several Council of Europe states who already have it. So as I mentioned, Denmark, Belgium, Iceland, Ireland, and many more. So there is that could have been taken as a consensus, but sadly they didn't go that route. And there's also Council of Europe institutions, for example, who've recognized that self-determination would be the way to go. So for example, the Parliamentary Assembly of the Council of Europe already in 2015, so 2 years before that judgment, recommended self-determination and also recommended that clearly that there should be no mental health diagnosis imposed on trans persons for their legal recognition. So those resolutions are not binding, but the court has taken them into account in previous judgments. So it wouldn't be unusual for the court to take into account what Pache has to say about the issue, and in this case, it sadly didn't. The Council of Europe Commissioner for Human Rights has also recommended self-determination for intersex persons, and even mentioned that it might not be proportional to even require gender markers on identity documents at all, so going even further in the deregistration approach that we were mentioning just earlier as well. So moving on to a second contentious issue here, the court's jurisprudence has been criticized for perpetuating a heteronormative model of gender registration. So that's also something Damian was mentioning earlier. But Canute and DeCoster here in that case have been arguing that by allowing binary sex and gender registration, and that's something that the court has taken as a given. It hasn't questioned it at all, as far as I'm aware. It hasn't even posed the question of whether it's necessary. The court really legitimizes and imposes a heterosexual cultural system of gender. So meaning that as long as sex and gender are recognized as existing in the binary model, they exist in opposition to each other. And so they only truly function within heterosexual norms. So that in terms of queer theory, for example, it's been demonstrated that it doesn't necessarily make a whole lot of sense to have it that way. And sex and gender are not biological, they're not binary. It's been demonstrated over many years. So really the only way, it's been argued, to avoid this heteronormative and not biologically correct system would be to cease registration of sex and gender. And that's also something that the Commissioner for Human Rights even argued for. So, and that wouldn't necessarily mean that social gender wouldn't exist in our societies. It would just mean that it wouldn't be assigned by the state, but then it could be something that's personally cultivated, for example. Sorry, I think I'm speaking a bit fast. I hope it's okay. So moving on to the last point here on the contentious issues, the court has also been perpetuating stereotypical gender norms and roles in its judgments, which is quite interesting when you take into account the fact that in 2012, the court itself said that states may not impose traditional gender roles and gender stereotypes, but then the court goes on to do the very opposite in its judgments, it seems. So for example, in the case of Goodwin versus UK, but even more so in Wayvay versus Turkey, which is newer than Constantine Markin, where it said that there could be no stereotypes, the court has called has judged cases on trans issues by referring to a social gender role. And I don't know what you all think of that, but personally, I don't really see how it would be possible to define a social gender role that doesn't make reference to stereotypes or gender roles or gender norms. And that's something that the court says that it's clearly opposed to. So there seems to be a contradiction here in the way that the court approaches stereotypes for cis persons and trans persons. That doesn't necessarily make a whole lot of sense. And there's also, interestingly, another case, a recent case of Derechos versus Croatia, sorry if I'm mispronouncing that completely, where the court said that only women could become pregnant, which seems like a very interesting statement when you take into account that in AP Gaston and Nico versus France, the court also said that legal gender recognition didn't require sterilization. So that very obviously means that trans men can get pregnant and do get pregnant. But then that doesn't make sense with their 2021 judgment, in this case, that only women could become pregnant. So there's some contradictions here in the way that the court approaches these issues that seems sometimes quite stereotypical, and there is clearly some contradictions here that it would be interesting to see the court, well, at least recognize in the future. So speaking of the future here, there are several cases that are pending now on gender identity before the court, and those may hopefully bring about some interesting changes as well. So for example, we have the case of Y versus France, which is the only one I'll get to mention today, but there are several interesting ones that will be judged on soon. But in Y versus France, this case concerns an intersex person who sought to have their intersex status recognized in the civil register in France by replacing the male sex marker by neutral sex. And the Court of Appeal refused this on the basis that the applicant had a masculine physical appearance, which was due to a medical treatment for osteoporosis, and the court knew this. And they also based it on the fact that the applicant had the social behavior of a man, which was partly due to their marriage to a woman. So heteronormativity then again. And the Court of Cassation then confirmed this judgment, including that reliance on appearance and social behavior of the applicant. And the Court of Cassation also held that even though sex registration did fall under the scope of Article 8 of the Convention, it was necessary for the social and judicial functioning of the state, and thus became a justified interference with the right to private life of the applicant. So there's been a third-party intervention now that the court has gone to, the case is, the application of the case has gone to the court. There's a third-party intervention that's been sent in by Benjamin Montpech in the name of several organizations, which writes that France has failed both in its negative and positive obligations under Article 8 of the Convention. So first, in its negative obligations, as it interfered with the applicant's right to private life by forcing them to live under an identity that doesn't match their reality, but also in its positive obligations then by failing to provide the adequate means for the applicant to legally change their gender and fix the initial failed negative obligations there. So Montpech then argues that in this case, the court must find that the fair balance between the applicant's interests and the general community's interests, whatever they were, as you mentioned, Damien, must weigh towards the applicant, because this is an issue of particular importance to their identity, which then narrows the margin of appreciation that's allowed to states, as I mentioned earlier. He also argues that because the issue is one that targets a particularly vulnerable group with a history of discrimination, the margin of appreciation should be even further narrowed. And even more, there's another point of a consensus here that arises because there is a clear and continuous trend towards legal gender recognition of intersex persons. And as I mentioned, that can be interpreted as a consensus under the court's jurisprudence. So there's quite a lot of points here that point towards recognition of intersex persons if the court were to follow its own jurisprudence in the issue. And there's also the fact here that the applicant hasn't argued for this option to be created for all persons, but only for their own to be changed. But this does leave the court open with the possibility of creating new right and new interpretations of Article 8, which would be incredibly interesting, but then the court does have to decide the extent of that right if it creates one, if it does judge in favor of the applicant. So for example, the court might merely go in the way of, for example, recognizing intersex gender by basing it on a medical diagnosis of intersex variations. But it may also go a bit further and recognize non-binary identities, for example, by basing it on self-determination. Or it may go even further and, as I mentioned earlier, go for deregistration of gender and follow, for example, the Belgian Constitutional Court's 2019 judgment in suggesting the elimination of sex and gender identity as elements of a person's civil status altogether. But that does maybe seem a bit more unlikely, even though it would be very interesting if the court did take that approach. So in conclusion, the court has produced some major advancements, and that has been both in terms of legal recognition to prohibition of sterilization to social and family rights. But there is also very clear room for improvement. And with those clear and continuous trends that are now moving towards demedicalization of trans persons and the recognition of identities outside of the binary, there is hope that the court might follow those trends in the near future, and hopefully trans rights might move forward within the Council of Europe states as a whole. Thank you so much, and here are the sources if anyone's interested. Thank you.